Hello, I'm Nick Hobden, partner in Thompson, Son & Passmore, based in Kent, and I'm joined today for this video about the Special Educational Needs Tribunal by Sara Ibrahim of Gatehouse Chambers, who we've worked with on some cases, and also Jessica Wells of my team. So today's video is about things to do with how a school is going to defend a Special Educational Needs Tribunal and also the process of the claim itself. So Jess, can I just turn to you first and ask you, what are the grounds on which a school might defend a Special Educational Needs Tribunal?
Absolutely. So the first things to consider is really what the claim is about. So it will be unique in different circumstances. The child will be bringing different discrimination claims. They'll be bringing different claims about different disabilities that they may have. So as Sara mentioned, there are different forms of disabilities, both mental and also physical disabilities. So the school will have to consider the differences. But the first thing is really, is the child actually disabled? Because as I've mentioned before, that underpins the whole claim. So firstly, are they disabled? Does their disability meet the definition that Sara's mentioned in the Equality Act? And if not, then really the claim goes away. But if so, then the school need to be looking at that and considering what that disability has meant. And I'll come on to their knowledge in a second. But if, for example, they cite stress as the disability, well, stress doesn't necessarily meet the definition under the Equality Act, whereas other disabilities such as anxiety or depression, as Sara's mentioned, may do. So they need to be looking at that. That's the first thing. Can they defend whether there is actually a disability there or not? And secondly, if there is a disability that the student has cited, then potentially medical evidence. The school needs to be considering whether they've received medical evidence, whether they have seen medical evidence, and that will play into their knowledge. So did either the young pupil or parent or guardian say, my child or I am disabled and here is the evidence to prove that? If not, then potentially they could say they don't have actual knowledge of the disability. And if it's a case of, well, they've looked through attendance, they've looked through the pupil's behaviour and they can't necessarily see that there were any indications of a disability, then potentially they have a response to constructive knowledge as well. So they're things that they need to be considering. They also need to consider if the pupil has left the school since the claim has been brought, then, or since the time when the discrimination was alleged, then actually is the disability related to when they have alleged the disability? So for example, if they have medical evidence, does it date back to when they're actually saying that discrimination happened, or is it afterwards? So that's something that the school will need to look at as well. And also they need to be looking at their own internal policies, their own internal procedures that they've undertaken. So for example, the school could say, well, actually we have anti-bullying policies, we have complaints policies and other policies that may impact on their ability to defend a claim, and they should be looking at whether their members of staff have been trained on those, whether they can feel confident that those policies have been applied correctly, and potentially looking at, and I know that we'll come on to this later in this video, but have they looked at offering reasonable adjustments? Have they got a track of offering a mentor to the young people if they need it? Have they had one-to-one meetings? Have they made a log of all the bullying accusations or complaints provided? And if so, then potentially there are good grounds to defend a claim. And I've said, though, it really depends on what that claim is about, the particular types of discrimination, disability discrimination claims that have been brought, and it will be unique on on each individual claim that's raised. But those are the things that the school should be looking out for and thinking about when looking to defend a claim.
So I now want to talk about how a Special Educational Needs Tribunal approaches a case and what both the claimants and the respondent, or the responsible body, which is usually the name referred to the school that defends those sorts of claims, have to do in connection with the claim. Well, like most tribunals and courts, the Special Educational Needs Tribunal is no exception when it comes to the guiding principles about how the case is resolved and what both parties are expected to do. They are supposed to further what is known as the overriding objective, which is the overriding objective of dealing with cases fairly and justly. And what that means in practice is that they have to deal with the case proportionately, so that they have to seek directions for the case management of the case which is proportionate to the issues in the case and is not unnecessarily wasteful or heavy in documentation. They must also reduce delay and also act fairly and proportionately with each other and not try and score points. That's really what it translates to in practice. So you very often find that judges in the Special Educational Needs Tribunal will stand back whenever they get a request from one party to change their case management order about how that particular change is going to further the overriding objective. Is it going to save cost? Is it going to reduce or result in more delay? And that's the way they approach things. Now, this translates further into issues to do with split hearings. Split hearings are often ordered when there is a discrete issue to be tried, separate from the main issues, to do with, for example, time limits, or whether, for example, the child is disabled. Generally, the practice of the Special Educational Needs Tribunal is to hear the case all in one go. It may split off the hearing into sections to deal with issues like disability and time limits, but generally speaking, it is interested in making sure that that case comes to a hearing within that 20-week target date from when the proceedings are commenced. So, in certain circumstances, the tribunal may order a split hearing to deal with time limits when there's an obvious issue about time limits appearing on the face of the documents. So, for example, a claim was brought more than a year after there was an alleged failure to make reasonable adjustments. The tribunal is more likely to order a split hearing in those circumstances to deal with that particular discrete issue. So the last section of this third part of the video, I want to talk about the protections that these schools can avail themselves when dealing with the Special Educational Needs Tribunal claims to defend those. Sara, can I ask you what sort of protections are available to the schools in those circumstances?
Well, Nick, the good news is there are quite a lot of things schools can do. I would split it into two categories, really. That's preparatory steps, things that schools ought to have been doing before a claim comes in, and kind of considerations for when there is a complaint, etc. So Jessica has mentioned some very important things, and that's having the right policies in place. And those will certainly be expected because the Department for Education has done a lot of model policies. So if you have no policy at all, that's going to very much be frowned upon. So do have a look at those policies. And if you are going to adjust them or amend them, make sure that you've really thought about why you're departing from those model policies. Another thing is to make sure your staff know how to use them properly, because there's no point having policies that are passed that none of the staff know about, particularly if you're updating policies. That can be a key place where schools very much get caught out. I think the other important point, and just to echo what Jessica said, it's things like logs of complaints, and that's everything from bullying to informal complaints. And why do I say that in particular? Well, if you've got a young pupil, they're far more likely to be making complaints in person, and you're going to be expected to record that, because otherwise you're not going to be seen to be proactive. That's another point I want to make. Please do make sure as a school that you're being proactive. So if there are incidences, for example, somebody's been absent for prolonged periods of time and you've not been told why, I think it is helpful if a school does actively make investigation into those kinds of things. I think another point I want to touch upon, and which schools may not always automatically realise, and that we touched upon in part 1 with reasonable adjustments, there is this duty for schools to be proactive.
Yes.
So there will be certain policies that they may have in place which amount to being a PCP. That's a provision, criterion or practice for those of you who can't remember from part 1. So where those policies may have an indirectly discriminatory impact, a school, if they have a disabled pupil or pupils, has to think carefully about whether they can make some adjustments or amendments to those policies. And that can be a very important way that they can protect themselves from claims.
So it's almost really like an impact assessment, if you like, really, that they consider the impact that that policy might have on a child who may be disabled and the type of disability involved.
Absolutely. And I think that's a good analogy, because schools are very used to doing those kinds of impact assessments. And in the very best practice, which we would hope schools would be thinking about, they will be doing that when they're actually amending their policies. So that's right at kind of board level, and they're thinking about how there may be categories of certain types of disability that they may wish to make adjustments for.
Yes.
I mean, can I touch upon exams as just a very common
Please do.
example? So when you're getting either usually internal exams, which can now be an important component of being assessed, you may want to think, for example, do certain pupils need additional time? Some pupils are going to find, if they are sensitive to stimuli, they may need to have that exam in a quieter place. And those are just 2 examples that you can be thinking about, where schools will be encountering cohorts of pupils having to have exams on a very frequent basis. So that is one thing I think schools can think about proactively, just to come back to that word of being proactive. I also want to touch upon something that Jessica said as well, which is the allocation of mentors. Sometimes having a one-to-one, we sometimes use the expression peer mentors, but that doesn't necessarily mean they have to be in the same year group. It can often refer to people who are a couple of years above. That is something that a lot of pupils find it a very, very useful way of assisting them. And that's not just an adjustment. Think about the points we were discussing in part 1 of the video, harassment, for example. Yes. If you're thinking about the kind of environment you're trying to create and how comfortable those pupils are, then having a peer mentor, they may be able to have different types of conversation than they may be having in the more formalised discussions with teachers and other conversations they're having in the school. I also think that there are very practical examples that you can think about with disability. Access to facilities. Do you have appropriate disabled access for toilets, for classrooms, things of that nature? There will be certain ways that auxiliary aids can help. In another part, we talked about people with sight impairment, and there are very obvious things you can do there. Yeah. But if you have, for example, a wheelchair user and you schedule all of their classes, say on the top floor or the second floor, and you only have stairs, that's an obvious thing that you can adjust, and you could adjust relatively swiftly, one would hope. So these are the kinds of things I think you ought to be thinking about. So it's not static. I've talked about what you can do before claims and what you do when perhaps a complaint comes in. You can also alter your policies as you go along, and I encourage schools to be very much in a reflective mode, and when complaints are made, whether they're formal or not, to start thinking about the adjustments, because you find that it is a lot easier to do things in that sometimes incremental way than to wait for a claim and then learn the lessons at the end.
Exactly, yes, good. Thank you very much indeed, Sara. Thank you, Jessica. I hope that's been helpful in terms of looking at the anatomy of a special educational needs tribunal, and that you've derived a lot of information from that which will be helpful for your own circumstances. Thank you very much indeed.